Welcome to the hearing of the House Committee on Judiciary and Hawaiian Affairs. It is Thursday, February 8th, 2 p.m. in Conference Room 325 here at the State Capitol. We're also running this hearing by video conference. We're here today for the purposes of hearing numerous bills. I would like to request the testifiers keep their testimony to 2 minutes, and I'll ask you to wrap it up at that point. If you're testifying by Zoom, please keep yourself muted and the video off while waiting to testify, and then re-mute yourself and turn your video off after your testimony is complete. If you're testifying via Zoom, you can use the chat function to chat with the technical staff only for technical issues. If you're disconnected, don't panic, just try to rejoin, and then I'll do my best to get you some time to provide your testimony. If the electricity goes out in the Capitol and we have to reschedule the hearing or schedule a meeting for decision making, we'll make sure to post appropriate notice. When you're testifying via Zoom, please avoid any trademarked or copyrighted images because that kicks us off of YouTube, and that's a problem. And please, everyone conduct themselves with aloha. Please, no profanity or uncivil behavior. It's okay to disagree, but please don't be disagreeable. We're all working together for what's best for the state of Hawaii. First up, we have House Bill 2064 relating to licensing. This measure includes the prevention of activities within an applicant's premises and adjacent areas that are potentially injurious to the health, safety, and welfare of the public and neighborhood as a factor for determining whether a controlled substances registration is in the public interest. First up, we have testimony from the Department of Education. Welcome.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. Ken Kakisako of the Department of Education. We stand on our testimony in support.
If you would please give us the highlights of this and what does this have to do with in particular?
Yes, so what we're looking is we just want to make sure that around our schools in particular, that areas, businesses around the schools are appropriate and are going to not be injurious to our schools. And so in particular, we are looking, there's a school right around this area that has a clinic, a methadone clinic that is nearby that sometimes is not, we don't think it's appropriate to be necessarily near a school. And so that's what I think the bill is addressing at this point.
Okay, and I would note that your testimony, you defer to the Hawaii State Departments of Health and Department of Law Enforcement for comments. And that's in your testimony.
I'm sorry, Chair. It's just because the statute itself sits under the Department of Law Enforcement, so it is not our statute, so we are deferring to them in that case. Yeah.
Okay, thank you. Anyone else wishing to testify on HB 2064? If not, questions, members? You can come back up. I just wanted to ask you, what do you want to hear from what kind of advice do you need from the Department of Law Enforcement or Department of Health?
Well, no, actually, it's just because it's being put into their statute, we don't want to put things into their statute. So just deferring to them if they're okay with that. Okay. That's really it.
Okay, all right, thank you very much.
Yep.
We do not have testimony from the Department of Law Enforcement. I've asked the Deputy Director to go back and see if they can get testimony and get it to us as soon as possible. I may recommend we defer this measure when we get to decision making until we get comments from Department of Law Enforcement and Department of Health because they have not submitted it this time. There being no further questions, let's go ahead to the next measure. House Bill 2071 relating to photo red light imaging detector systems. This measure provides that any photo red light imaging detector system's clear and unobstructed recorded image of a motor vehicle license plate shall be prima facie evidence that the motor vehicle to which the license plate is attached is the motor vehicle for which the license plate was issued. It requires the state, the county, or the state's and county's third-party contractor to implement a process to record the date on which the summons or citation was submitted to the post office, which shall be prima facie evidence of the date the summons or citation was submitted to the post office. First up, we have testimony from the Department of Transportation on Zoom.
Aloha Chair Tarnas and members, Melissa Miranda Johnson for the Department of Transportation will be standing on our testimony in support of the bill and available for any questions you may have.
As usual, I ask you to summarize the highlights of your testimony. Would you please do that?
Yes, the highlights of our testimony is just to agree that if we provide unobstructed photographic evidence, that should be enough evidence for the courts to issue the citation.
Okay, thank you. And in your testimony, you also note that your vendor is currently working on a process to record the date on which the summons or citations was submitted to the post office, and they are confident that the new process could be implemented by July 2024. Is that accurate?
That's correct.
Okay. All right. Thank you very much.
Thank you.
Next, we have testimony in writing in support from the Disability and Communication Access Board and testimony in opposition from Michael Cobb. Is there anyone else wishing to testify on House Bill 2071? If not, questions, members? Seeing none, we'll move on. Thank you. House Bill 2621, relating to law enforcement. This measure establishes a task force on ethical policing to evaluate the efficacy and impact of weed and seed programs and requires a report to the legislature. On this measure, we have testimony from Darcia Forrester, Office of the Public Defender. Welcome.
Aloha.
Please proceed.
Aloha, Chair Tarnas and members of the committee. So the Office of the Public, my name is Darcia Forrester. I'm a Deputy Public Defender. We submitted testimony in support. We do think it's about time we started getting some data on the efficacy of the weed and seed programs that are in effect in the state. But the main reason we submitted testimony was to request that a representative from the Office of the Public Defender be included in the task force. There's a lovely long list of stakeholders, but we're not on that list. And we think because we represent the majority of the participants in weed and seed programs, we should have a seat at the table. Thank you.
Thank you very much. Next, we have testimony in opposition from the State of Hawaii Organization of Police Officers. Next, we have testimony with comments from the American Civil Liberties Union of Hawaii. Welcome. The floor is yours. Please proceed.
Aloha, Chair, Vice Chair, committee members, Carrie Ann Shirota, Policy Director on behalf of the ACLU of Hawaii. We've submitted comments. I think it's no surprise that we have serious concerns about the efficacy and effectiveness of the weed and seed program, but we'd like to highlight sort of the bigger picture here. It appears that weed and seed has funding from different sources, and most recently from the Department of Justice Bureau of Justice Assistance. Just doing a quick search online, it appears that in 2021, they received a grant, and as part of that grant, there are reporting requirements, evaluation, different benchmarks along the way that is allegedly should have been due in September 23rd, specifically looking at the efficacy and effectiveness. So what we're suggesting is that those reports be made public. When I went online to the Weed and Seed website, nothing was available for years, no data at all. That data is also made available to lawmakers. And also, if this task force moves forward, we suggest that rather than only honing in on weeded seed, which we needs to have a third-party evaluation, that we also zoom out and take a look at alternatives, responses in under-resourced communities. What is the most effective? Typically, when we convene task force, we bring in experts from diverse groups. So we'd like to see a task force group around reimagining public safety. Oakland, some other cities, states have engaged in this process and really asking community members what they need and then evaluating what is most effective. And that's what we should be putting our resources in. And finally, to echo the comments from the Public Defender's Office, if this task force proceeds forward, we also ask that there be more community members who are looking at criminal justice reforms and looking at effectiveness in terms of evaluating what's possible and what's best to truly build healthy and safe communities. Thank you, representatives.
Thank you very much. Next, we have testimony from Angela Melody Young, Kapalama Neighborhood Security Walk. And testimony, no, she's not on Zoom. And testimony from Kat Brady, Community Alliance on Prisons. Please proceed, Ms. Brady.
Aloha. Thank you so much, Chair Tornes and members of the committee. Kat Brady testifying in strong support of a task force to actually evaluate weed and seed. Actually, At a presentation of the Breaking Cycles Symposium that happened in October 2023, there was a slide that showed the breakdown of people in jail. 75% of the people in jail are in jail for Class C and below violations, misdemeanors and violations. That's insane because the director actually testified recently at a hearing that it costs $254 a day to incarcerate somebody. So we are spending a lot of money incarcerating people who probably have the least resources, and they're the largest group in the prisons, in the jails. That's kind of crazy. So right now, as of January 29th, there was 1,683 people in jail statewide. That's 44% of the entire incarcerated population. I think we need to really dig deep, look into weed and seed. Is it effective? Is it just spreading a net for low-level lawbreakers, or is it actually doing things that protect the community? Thank you very much for this opportunity to testify.
Thank you very
Aloha.
much. Next, we have testimony in opposition from John Deutschman. Anyone else wishing to testify on HB 2621? If not, questions, members? Oh, go ahead, Rep. Kennedy.
Okay. To Ms. Forrester at the Office of the Public Defender. Yeah.
You want to share it with him?
Yeah, I'll start. Good afternoon.
Good afternoon.
For kind of our education, how does weed and seed work? Is it like a geographic area in which the prosecutor decides to emphasize higher sentences, or how does this work?
A combination of, well, it's geographic based. So when you're in so first of all, you have to be placed on some sort of supervision that includes a weed and seed geographical restriction. And that geographical restriction will include limitations on your entering the area. Sometimes there are exceptions depending on your job, if you have a job. And it will, it could also include additional restrictions linked to like substance abuse issues, mental health resources, that type of additional add-on to the conditions of your supervision. But essentially, you get a limitation on whether you can enter the geographical area at all, or if there are severe restrictions on your access. And it's based on a crime being committed within that geographical restriction. So you can't, for example, commit a crime in Kaneohe and then get a geographical restriction for the Waikiki area. It's targeted to crime in that particular geographical area.
So, where are some examples of weed and seed areas?
The Waikiki has its own area. There's the Kalihi area or Chinatown area has a weed and seed area. I cannot.
Are we in a weed and seed area here at the Capitol, state Capitol?
I don't believe so. I would have to double check with our district court section. I'm here handling the bill, but I'm not sure if there is one in the Capitol. There may have been an attempt to create one, but I don't know if there currently exists one. It might be linked to the Chinatown geographical restriction. The maps are very elaborate. If you get placed on a geographical restriction, you get a map that is like street by street, and it's these elaborate, street restricted maps that you get.
And where you can or cannot enter.
Exactly.
As a parolee or as somebody who violated a crime or is alleged to have violated a crime.
Correct.
How long has the state of Hawaii been, and its various county prosecutors been operating with these weed and seed geographic restrictions?
I'm sorry, I cannot answer that question. Part of part of the problem is that we had weed and seed restrictions for some time, especially in Chinatown, and then they were sort of discontinued, and then they've been restarted. So I cannot tell you the start, like the first day when geographical restrictions were instituted, but
understand.
they've been around a long time.
Yeah, so we have I guess, puka in the bill that articulates how far we're going to look back. So we were just thinking of putting, say, at the onset of the program. Does that sound fair to you?
That sounds fair, because there have been times when geographical restrictions were not being given out. I think it was linked to federal funding, I'm not positive, but it's come and gone and returned. So if you do it from the onset, then you can have better data to compare what happened before COVID, after COVID, those types of things.
So this changes in this weed and seed map. Is this kind of just arbitrarily done by the Office of the Prosecutor? Or does the Public Defender's Office, the AGs, other state agencies have involvement in this conversation?
I'm so sorry. I just don't think I could answer that question accurately. I'm not sure who drew the maps. That might be an appropriate question for the prosecutor's office, because they're the ones that request the geographical restriction, and it might be linked to funding. I don't know who was at the table when they drew the maps. I'm
So just fair
sorry.
to say we need more information.
Yes, definitely.
Okay,
Yeah.
thank you so much.
Thank you.
Any other questions, members? If not, thank you very much to the testifiers. Let's move on to the next measure, HB 2218, relating to the Hawaiian Homes Commission Act. This amends the Hawaiian Homes Commission Act of 1920 as amended to increase the loan limit for direct loans provided by the Department of Hawaiian Homelands from 50% to 75% of the maximum single residence loan amount allowed in Hawaii by the United States Department of Housing and Urban Development's Federal Housing Administration. This takes effect on either the date of the Secretary of Interior's notification that congressional approval of this act is unnecessary or on the date of consent by the U.S. Congress. First up, we have testimony from the Department of Hawaiian Homelands. Welcome. Please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, members of the committee, Ovao o Oriana Leao, Nahas, the Government Relations Program Specialist for DHHL. The department stands on its written testimony in strong support of this measure. In summary, this proposed amendment to Section 215 will allow beneficiaries to purchase and make improvements to their home, and I'm available for questions.
Thank you. Anyone else wishing to testify on HB 2218? If not, questions, members? Yes. Thank you so much for being here. My question is, what's the process you go through? Let's say this does pass the legislature. How do you go about notifying the Secretary of Interior that we've done this, and how do they go about determining whether congressional approval is necessary or not?
Because this is subject to congressional approval, first, the Secretary of the Department of Interior would have to review and approve. If she, Deb Holland, determines that it has to go through further steps, it does, and then Congress would have to vote in majority favor of it.
So the Secretary first determines whether or not congressional approval is necessary.
Yes.
Got it. And then if she decides it is necessary, then she has to then request the Congress to take action, and then the measure would not come into effect until after the Congress takes action on it.
Correct.
Okay. Okay, thank you very much. Any other questions, members? If not, we'll move on. Thank you so much for being here. Moving on to the next bill, House Bill 1886, relating to fire protection. This measure authorizes the use of the Reduced Ignition Propensity Cigarette Program Special Fund to support the State Fire Council and its programs and activities, including for the hiring of administrative personnel. First up, we have testimony from the Department of Land and Natural Resources. Smokey the Bear, or his representative? Ha 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 ha. Hello, Mr. Walker.
Hi, Make Aloha. I'm Michael Walker. I serve as a statewide fire protection forester for the Department of Land and Natural Resources Division of Forestry and Wildlife. And the department stands on its written testimony. In summary, we believe that the Fire Council needs additional funds for administrative support.
Okay, thank you. Next, we have testimony from Bradford Ventura, Maui Fire Department in support, and testimony from Sheldon Howe, Honolulu Fire Department in support. Anyone else here wishing to testify on HB 1886? If not, questions, members? If not, I have a question. Mr. Walker, on a bill from last year, which I think was the same, and it didn't end up being approved, it was carried over. The Attorney General testified saying that the current functions of the State Fire Council do not include the functions listed in the bill, which is the same as we have here, and we recommend conforming the functions of the State Fire Council that are prescribed in Section 132-16 Hawaii Revised Statutes with the uses of the RIPC Special Fund, and that's the Reduced Ignition Propensity Cigarette Program, as proposed in this measure. Are you aware of that situation? Because this was something that happened a year ago, and this bill doesn't include anything to address that.
Yeah, so I joined the Fire Council at the beginning of this fiscal year.
Oh, that's right,
as
we
a
just
member.
added you.
Yes, yes.
So,
So
yeah.
I am fresh in
Got
this
it.
role. However, I'm not quite sure whether they're speaking towards the other programs, such as the training and the fire alarms, et cetera, or are they referring to specifically the hiring of administrative staff to support the reduced propensity
Yeah,
program?
I think they're looking at all the things that are added in this bill, including the personnel. Make sure that that's in there. I think the personnel is probably in here, but it's all the other things that are listed in the bill that the Attorney General said that it's not already in your purposes for the State Fire Council composition and functions. So what I may end up having to do is recommending to the committee that we move this forward, defect the effective date, and then request the State Fire Council to come back, look at what else is needed in order to address the Attorney General's concerns, and then address that either in the Finance Committee, which gets this next, or if it is successful, moving over to the Senate, could address it over there.
Okay, that sounds good to me. Thank
Yeah,
you.
so that's probably what we'll end up doing. And then they also had questions about whether the funds allowed to be expended for the hiring of administration personnel would apply to existing staff, or whether these funds are intended to apply to other staff to be hired after the enactment of the bill. And that, they also asked for clarification on that, which is not clear.
Okay, yeah, I'll get those clarifications.
So I'll so look, and I'll say this in decision-making, but it was last year, House Bill 143, that testimony from the Attorney General where these items were brought up. So if you could have the State Fire Council look at that and prepare recommendations for a future committee, that'd be great.
Yeah, I've already emailed the chair of the Fire Council as well as the administrative assistant to address these needs.
Okay, great. Thank you, Mr. Walker.
Thank you.
Appreciate it, and thanks for bringing Smokey.
Always.
Okay, any other questions, members? If not, we'll move on. Next, we have HB 2232 relating to weapons. This measure requires the Department of the Attorney General to publish certain annual reports regarding restraining orders, firearms, and electric guns. Authorizes persons subject to certain restraining orders to possess or control firearms, ammunition, or electric guns in the course of employment subject to certain conditions. On this measure, we have first up testimony with comments from the Attorney General. Welcome, please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and Member Ganadin of the House Committee of Judiciary and Hawaiian Affairs. My name is Lauren Haugen. I'm with the Attorney General's office, and I thank you for this opportunity to testify today in front of you. on House Bill 2232. As noted in my written testimony, it's basically to request that the Chapter 134, subsection A, found on page 1, lines 4 to 9, just be amended to comport with the department's main recommendation, which is to amend subsection B, found on page 2, lines 3 through 7, which basically gives the county police agencies, the Department of Law Enforcement, and the judiciary more time to compile the data that's being requested in this bill to a date to reflect March 31st. Other suggestions in the testimony that's been provided are mainly technical edits to House Bill 2232. And again, thank you for the opportunity to provide testimony and comment today. I'm available for questions.
Sure. Thank you very much, Deputy Attorney General. Your testimony always helps us make better bills.
Thank you, sir.
Next, we have testimony in opposition from Bronson Texera and testimony in support from Marcela Alohalani Boydo. Is there anyone else here wishing to testify on House Bill 2232? If not, questions, members? Representative Ganadin, please proceed.
Mr. Hagen, sorry for having you step down with the Office of the Attorney General. Good afternoon.
Good afternoon, sir.
A lot of us have become concerned about the use of firearms by respondents in restraining orders after the issuance of a restraining order. The case that really comes to mind is the Cachuela case that happened just prior to Christmas. A restraining order, to my knowledge, was issued on a Wednesday, and the incident, which involved 2 fatalities, happened on a Friday. In 2021, this legislature changed the process by which respondents are told to submit their firearms to county police departments or to the Office of Law Enforcement. Have you collected data on the efficacy of that 2021 act to this date?
I would love to answer that. I don't think I'm equipped to answer that today, Mr. Ganadin, Representative Ganadin. My apologies. I don't know if our department collects that as of yet, but I can take that back and definitely answer your questions at a later time.
I think the concern that we're hearing from constituents and advocates is that, protective order is just a piece of paper, and that we're trying to lessen fatalities here and just basically track data. Is there any other information that you could, that you think that we should add into this bill in order to better bolster our information so that we can better create a new law around restraining orders?
Not at this time, Judge.
Thank you.
Thank you, sir.
Any other questions, members? If not, we'll move on. Thank you. House Bill 2295 relating to the traffic code. This measure specifies that the counties may issue traffic infractions for violations of any law prohibiting or restricting the stopping, standing, or parking of vehicles on all highways and county property. It authorizes stopping, standing, and parking restrictions and prohibitions on property under jurisdiction of the Department of Transportation and the counties, respectively. On this measure, first up, we have testimony in support from the Department of Transportation.
Aloha, Chair and committee members. Melissa Miranda-Johnson with the Department of Transportation. We stand in support of this measure. In summary, our testimony states that adding the language allows county's property allows the county police departments to issue citations for people that are stopping, standing, or parking on their highways and also county properties and causing unsafe environments for other motorists.
Thank you very much. Next, we have testimony in support from the County of Maui, Mayor Richard Bisson, and the County of Maui County Chair Alice Lee. Anyone else wishing to testify on House Bill 2295? If not, questions, members? Nope. We'll move on. Thanks very much. House Bill 2455 relating to private security contracts. This measure, effective January 1st, 2024, transfers the responsibility and management of certain private security contracts from the Department of Law Enforcement to the Department of Defense, the Department of Health, and the Department of Human Services for their respective facilities. On this measure, first up, we have the Department of Law Enforcement. Mr. Vincent. Deputy Director, welcome. Please proceed.
Good afternoon, Michael Vincent, Deputy Director for Administration for the Department of Law Enforcement. Chair Tarnas, Vice Chair Takayama, members of the committee. This is a housekeeping measure. Prior to the formation of the Department of Law Enforcement, these three departments, Department of Defense, Health, and Human Services, were already taking care of their own private security contracts, even though the statute says Department of Public Safety was supposed to do that. When Act 278 was enacted, it put Department of Law Enforcement there. What this bill is trying to do is actually just change the statute so that it reflects what's really going on with these private security contracts. Because these agencies are in the best position to actually determine their specific needs, given the number of facilities and the unique nature of a lot of their facilities. Thank you.
Great, thank you very much. Next, we have testimony from the State Department of Health. Welcome. Please introduce yourself. Please proceed.
Aloha Chair Tarnas and Vice Chair Takayama and members of the committee. My name is Naomi. I'm from the Department of Health representing Hawaii State Hospital, and we stand in support of this bill because we do manage our own security contracts. I'm available for any questions if you have any. Thank you.
Great, thank you very much. Is there anyone else wishing to testify on House Bill 2455? If not, questions, members? Seeing none, we'll move on. Thank you to the testifiers. Excuse me. Next up, we have House Bill 2266 relating to tort liability. This measure permanently reinstates the liability protections previously afforded to county lifeguards providing services at state beach parks or in the ocean. On this measure, first up, we have testimony and support from the Department of Land and Natural Resources. Mr. Cottrell, welcome. Good to see you, sir. Please proceed.
Good afternoon, Chair, members of the committee. Kurt Cottrell, Administrator for the Division of State Parks, here on behalf of Chair Chang. We do support this measure. I'll provide some brief context. Many of you know this is a measure that it's one of those perennial kick the can down the road type of initiatives. It's been going on for a while. The primary basis from the county lifeguards position, and I need to point out, we have 5 different lifeguard contracts that we've been running for years and years. We have Ke'e Beach at Haena, Ke'awa'ula at Kaena State Park, Hapuna, also at Menino Valley at Kube, and then on Maui we have Makena. So we spend, it's about $5.7 million a year on salaries, and the past couple of years we've been fortunate enough to have enough funding to provide them with equipment. And we really cherish these partnerships. These beaches have been identified due to their unique hazardous conditions. Ke'e is a beach where drowning happens. Makena is a beach where the people have suffered spinal cord injuries. But it's been my understanding that for years the counties have been seeking a certain degree of immunity for their contractual relationship with us at state parks. And I know the plaintiff's bar has lobbied effectively against this, pretty much using the nexus that firefighters and police do not get an immunity for their type of action. But I just want to, for the record, State Parks supports this measure, and anything we can do to help our county lifeguards be more confident in executing their duties at our state park beaches, we'd appreciate.
Thank you very much. Next, we have testimony and support from the Hawaii State Association of Counties, a member from Maui County Council.
Aloha, Chair Tarnis. The Hawaii State Association of Counties, all 4 counties of the state of Hawaii, strongly supports this bill. And we would even love it if you applied it to county lifeguards statewide. Formerly, before being elected to office, I was an ocean safety lieutenant on the island of Maui. And to echo what Mr. Kurt Cottrell had said, that there's been arguments that fire and police do not have this type of protection. It doesn't apply to gross negligence or wanton acts of omission. It applies to, the the difference between being an ocean lifeguard and a pool lifeguard or a firefighter or a police is, you know, a firefighter or police could be driving on the road and doing their job, but the road isn't going to move. You know, over the years, ocean safety lifeguards, they've joined the 911 response system, and they respond far outside the boundaries of the state park or the county parks. And they respond to 911 calls during their working hours. And it's such a dynamic environment that things can occur, and depending on how many people you have responding to the call, whether you're using a jet ski or a quad, it's just physically impossible sometimes to do all the things, although you're acting in good faith. And it's just that extra protection. As lawmakers, you must know that people can be sued at any time for any reason. And this is just one layer of protection to our lifeguards who don't make the same types of salaries as police or firefighters, and have a very real fear that they will lose everything in a lawsuit. Thank you.
Thank you very much. Next, we have testimony in support from the Hawaii Government Employees Association.
Good afternoon, Chair, Vice Chair, and members of the committee. Joy Kuwabara on behalf of Randy Pereira of the Hawaii Government Employees Association. We have submitted testimony in support as the exclusive representative of the lifeguards statewide. We do believe that the lifeguards should be able to perform their duties without any fear or concern. There have been discussions held with me personally that, you know, there are many times that the lifeguards would have to respond to situations because beachgoers fail to heed their warnings or the preventions, things like that. And, you know, as the previous testifiers, I appreciate their support as well. I'm available for questions.
Thank you very much. Next, we have testimony from the Hawaii Association for Justice. Mr. Oi, please proceed.
Aloha, Chair, Vice Chair, members of the committee. Evan Oy on behalf of the Hawaii Association for Justice. HHA respectfully opposes this measure. HHA has always maintained that giving lifeguards immunity for performing their duties in an unreasonable or negligent manner is bad public policy and compromises safety for residents and tourists alike. Hawaii law requires that all first responders, such as ambulance, EMTs, police officers, firefighters, emergency room doctors, and nurses, perform their jobs with reasonable care under the circumstances. There is no public justification for condoning a negligent job performance, nor is there any justification for treating lifeguards any different from other first responders who provide equally dangerous services. To be clear, HHA is not against lifeguard services. In fact, our lifeguards have provided exemplary service for over 100 years and are among the best in the world. However, this measure is unnecessary as lifeguards who serve at state parks are already entitled to defense at no personal cost by the AG under the State Tort Liability Act, HRS 662-16. This is the same is true in when lifeguards work at county beaches, because counties are similarly liable for negligent acts of their employees and therefore defend lawsuits and pay settlements and judgments. Immunizing lifeguards and counties from civil liability endangers our residents and visitors without a valid reason to enact such a drastic measure. For these reasons, HHA opposes this measure and will be available for any questions. Thank you, Chair.
Thank you very much. Next, we have written testimony and support from 3 individuals, Chantel Brown, Slainden Kauhaha, and James Hernandez. Is there anyone else wishing to testify on HB 2266? If not, questions, members? I have a question for Mr. Cottrell. Mr. Oy had said that county lifeguards serving on state beaches are considered employees of the state, and they're subject to protections under the State Tort Liability Act. And I looked it up, and it says any civil action or proceeding brought in any court against a county-based lifeguard on an allegedly negligent or wrongful act or omission of persons employed by a county as lifeguards at a state park. So it seems to me that they're already covered under the State Tort Liability Act. Why is it that they need immunity?
I'm a little bit out of my lane on this one. I know there's an AG here in the room that might be able to step in. I don't really know the vagaries of the Tort Liability Act itself. I just know, as the previous testifiers have said, based on the unique conditions of their job, they feel it's warranted to have that extra degree of immunity. But I suppose, as a layman, the concern would be if the legal defense failed, I would imagine, and then they would be liable. But again, I would defer to, legal counsel.
Well, as you say, this has been a perennial issue here.
Right.
It would seem that it would be very important for you to work with your deputy AG to answer this question definitively, because I'm hearing that they're already covered. I mean, I see employees of the state include persons employed by a county of this state as lifeguards and designated to provide lifeguard services at a designated state beach park under an agreement between the state and that county. And then employees of the state under 662-16, Attorney General shall defend any civil action or proceeding brought in any court against a county based on an alleged, I already read that.
Yeah.
So it seems like they're already covered.
That is how it reads, I would agree. I do remember from years ago, what brought this to the front was there was concern, I forget which of the contracts, but there was concern that when the act sunshined, that they would then pull out of their contracts with state parks.
Is there a
But we
Is
continue.
there a sunset on this? I don't see a sunset.
No, it did sunset, and they're trying to get it back, as I recall.
No, that was the immunity.
Correct.
I'm just talking about they're already covered, so why do you need immunity if they're already covered?
I cannot answer that.
Okay.
Other than it doesn't keep them out of court. I think the immunity would be,
State employees, if they, they may be brought to court, but the AG is supposed to be defending them.
right.
So lifeguards would be the same, right?
Correct. Again, but
So
if,
why do we want to treat lifeguards different from other emergency responders?
I would have to defer to the mayors of the counties, and all I know is that we cherish the relationship, we need them.
And I hear the counties saying they want this.
Yeah,
I just don't understand why, if it's in.
That would be a question, I think, better directed toward the Association of Counties.
Okay, thank you.
Okay, thank
Is there
you.
an attorney general here that works with this issue? No, okay. Could I ask the representative of the Association of Counties, Ms. Paulton?
Yes, thank you.
My understanding is, you heard what I was just saying. My understanding is that lifeguards are already covered. So why is it that they would need special treatment?
So as I said before, we worked in a dynamic environment, and lifeguards are the part of it is that they don't want to go to court at all.
Well, nobody wants to go to court, but, I mean, firefighters don't want to go to court either, but if they get sued, they have to go to court. I mean, that's kind of the way it works. So I just don't understand why. I mean, I have high respect for lifeguards, don't get me wrong. I have friends who are lifeguards. But as a policymaker, I'm trying to be very fair about it, and I just can't get my head around why lifeguards need to be treated differently from other emergency responders who also work in dynamic environments, who also don't want to go to court. But, they do, and if AG would be there with them.
So part of it is that, the ocean environment is not something that everybody understands, and the actions taken don't always look like what they really are. For example, if you are trying to reach somebody that is far out beyond the breakers, sometimes the direct course to get to them is not apparent to a bystander that's not familiar with the conditions.
Sure,
They
you
may be far out to
go a different direction in order to get there because the current's going to push you somewhere else. I get that, but
Yeah, and
that's
many
still.
of the people that we interact with, especially at the state beach parks, are tourists. And so, although we give them the warnings, they often disregard it. It's not easy to explain dangerous shore break. The words to them are like unfamiliar. They don't understand it. We'll do our best to do the preventative action. They do whatever they want in opposition to the advice that they've been given. then we go out to save them, and they don't always listen as you're trying to save them. It's a very unique situation compared to most other situations, especially the main people that we're trying to rescue have no knowledge or experience with the ocean environment, and so that is the concern.
Okay, and one last question. Thank you very much for that answer. One last question. How many lifeguards have been brought to court and that you're aware of for this situation?
I'm not aware of any. The only most recent court cases that I recall, there was one at McKenna State Beach Park. And that was the reason that we had originally pulled out with the agreement with the state, because of a drowning or incident that happened after the lifeguard's working hours. There's been other cases where the lifeguard wasn't directly held responsible, like jet ski collisions where we came in after the fact to save people, or propeller and human.
So these are two different cases where they brought to court?
I believe it was brought to court that I'm aware of, but I didn't follow the court case. We
sure.
just had to like testify or be deposed or things like that. And
Okay.
in those cases, the lifeguards were not held liable.
They were not held liable. Okay, well, that's good to know. Thank you very much. I appreciate that, council member. Mr. Cottrell, do you know of any cases where lifeguards were brought to court?
Only the ones that Ms. Pollen referred to.
That's it. Okay.
I remember the McKenna case, yeah. If I may, I'll offer a comparable kind of corollary to this. When I was running the Na'alahele Trail and Access Program, I consistently tried to amend Chapter 520, which is the state's recreational use statute, as I was trying to advocate for public access to private land, because typically private landowners, are non-receptive to public recreation due to liability. And I was always trying to get a certain degree of immunity for private.
I appreciate that.
It's the court part. It's going to court and whether or not they win or lose.
Okay, well, I appreciate your attempt to draw a corollary, but I'm talking about people, lifeguards who are considered state employees. It's different from a private landowner. Okay, thank you. Appreciate everyone taking the time to talk about it. Oh, you have a question? Representative Ganadin.
Sorry for Mr. Cottrell. Sorry for making you get back up here.
Oh, that's fine. Appreciate it. Thank you.
Yeah, no problem. I'm taking a look at the actual text of the bill, page 2, line 20, where it discusses claim for civil damages arising from a county lifeguard's alleged gross negligence, wanton act, or omission. It's that last word that's bothering me, omission. The reason being, we're, the ocean. Sometimes you have to decide as a lifeguard, I assume, to not act in order to not put first responders' lives in danger. For example, when somebody jumps into the water, like let's say at China Walls here, or by the blowhole or something like that, it would put many more lives in danger were you to act. Would you say that's correct?
Yes, there'd be a cumulative degree of risk, the more people that would be responding, yeah.
So would that be a version of an omission?
Oh, you guys are really testing me. I cannot answer that with any degree of succinctness. I apologize.
But you could see how a lawyer could articulate that would be an omission to act.
Yes.
Would you be happy with this bill if we were to take out that last word?
I would have to defer to I'd have to consult with the AG, because I don't want to damage any progress that they've made, whether or not this bill has any chance of passage.
Director, we keep coming back here year after year to discuss this. I'm trying to find a path forward for you here.
Appreciate it.
So gross negligence or wanton act, that seems like something that you'd be prepared to not go to court for. But, an omission, I think that's kind of stepping too far.
Good point.
Okay. Thank you, Chair.
Thank you. Any other questions? If not, we will move on. Thank you very much. Next, we have House Bill 1537. This measure is proposing amendments to the state constitution to authorize the legislature to establish a surcharge on residential investment property to increase funding for public education. On this measure, we have testimony with comments from the Department of Education.
Good afternoon, Chair, Vice Chair, members. The Department of Education stands on its written testimony. We're supportive of additional resources for education, very supportive of that, but we just have comments on the method of funding, or we reserve no comments on the method of funding.
And you also say, should this proposal pass, it is requested that collections be placed into a trust fund for the department to safeguard and ensure the funds are used for public education.
Correct.
Okay. Okay, thank you.
Thank you.
Good to see you again. Welcome back to the building. Next, we have written testimony in support from the University of Hawaii, testimony in opposition from the City and County of Honolulu, County of Hawaii, County of Maui, and testimony in opposition from the Hawaii Realtors. Ms. Garcia, welcome. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Lindsay Garcia from the Hawaii Realtors. So we respectfully oppose this bill. While Hawaii Realtors does support education, we are deeply concerned that an additional property tax surcharge for residential investment property will actually add to the cost of housing and rentals. There is a common misconception that such taxation solely affects wealthy or luxury properties. However, this could also directly impact workforce housing, including multifamily units and walk-ups in our state, which would fall into this particular range. The repercussions of any surcharge on property tax could be then passed on to the renters, further adding to the financial burden of residents in our state who are already grappling with the high cost of living and of housing. Thank you.
Thank you very much. I appreciate that explanation. Next, we have testimony in support from the Hawaii's Teacher Standards Board. Ms. Higa, welcome. Please proceed.
I'm Mitzi Higa on behalf of the Hawaii's Teacher Standards Board. We are in support of this measure, and we support, it is different from last time. I want to make that clear. The one that was overruled by the Supreme Court and thrown out, basically. This one is different, and it goes for the $3 million property. Again, it's not owner-occupied. It's for properties over $3 million. You've read the bill. But we are in support. We need more licensed teachers, and we need to attract and retain them. We're the only state in the nation that doesn't use some form of property tax to support our public education, and we really need to do that. Thank you.
Thank you very much. Next, we have testimony to comments from the Tax Foundation of Hawaii. Tom Yamachika. Please proceed, sir.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika, Tax Foundation of Hawaii. We have submitted written comments. Our primary concern is with the form of the measure. We understand that the measure is seeking something a little bit different from what was sought in 2018 when the Supreme Court struck it off the ballot. But our concern is that the way the ballot question is presented now, there's no mention of the word tax. There's no definition of what a surcharge is. The Supreme Court, in its 2018 opinion, talked about certain deficiencies in the ballot question that they haven't been addressed by this rewrite. So we are concerned that this is kind of going to be a history repeating itself if there's no substantial change in how the bill is worded at present. I'd be happy to answer any questions.
Thank you very much. Next, we have testimony in support from the Hawaii State Teachers Association. Welcome. Please introduce yourself and proceed.
Aloha, Chair, Vice Chair, and members of the committee. Laverne Moore speaking on behalf of Osatui, President of the Hawaii State Teachers Association. We support this bill. Increasingly, Hawaii is becoming the playground for the mega wealthy. It is unconscionable that as they harvest the benefits and splendors of this land offer, they don't also give back to our schools, which are falling apart and not providing our keiki with the schools they deserve. Educating our children in Hawaii is everyone's business. While the counties may feel that this is taking money from pots of money that they should exclusive have, Let me tell you, we're the only state that property tax does not pay for education. That ignores the fact that the state has to support counties in numerous ways. We cannot remain silo when it comes to investing in the future of our children. Ultimately, this would put the decision on whether our children are worthy of such investment in the hands of the voters of this state. Hawaii has the lowest property tax in the nation, and that is why investors come to Hawaii. Now is the time to put this issue in the hands of our voters. Thank you.
Thank you very much. We've received a written testimony from 10 individuals and organizations in support and 7 individuals and organizations in opposition. Is there anyone else here wishing to testify on House Bill 1537? If not, questions, members. Representative Holt.
I have a question for the Teacher Standard Board or HSTA. Teacher Standard Board. You know, noting Mr. Yamachika's testimony about the question that was tossed out once, and it seems that it's not changed too much. Would you guys agree, or do you think that the question currently would pass the muster of the Supreme Court?
It's changed quite a bit, actually, because when you think about what the question was last time and this time, the amounts change. It's a surcharge, but it also says it doesn't apply to affordable housing units. And last time it said real property, and this time it says residential property specifically. And if it stays that way, last time the legislature did change it along the way, and we're hoping it stays as it should be for residential investment property, not owner-occupied.
Well, one of the concerns was that the question was a bit misleading, and it did not explain that the counties had the explicit authority to tax, and that the question doesn't even have the word tax in it. So would you think that that issue has been addressed?
I think it has been addressed. A lot of constitutional law, like when it passes, it is quite vague, and it's later in courts that it's further defined. And so I do not think this would be overturned by the Supreme Court. That's my opinion.
Okay, and do you guys have an estimate on how much money this would raise?
Not at this time.
Thank you.
Thank you, Representative. Other questions, members? Nope. Okay, we will move on. Thank you very much. Next measure, House Bill 1651, relating to the safety of educational workers. This measure requires the Department of Education and public charter schools to take certain steps to report incidents of harassment and implement procedures for handling harassment of educational workers. And it creates the offense of harassment of an educational worker. First up, we have testimony from the Department of Education.
Good afternoon, Chair, Vice Chair, members of the committee. Ken Kakisako, Department of Education. The department does stand on its testimony with comments. We are fully supportive of protecting our teachers, administrators, schools, and district administrators. And that's where Section 4 of this bill is very closely mirrors what we have done in the past in attempting to try and make for stricter definitions of what harassment might be to protect our administrators. We were unsuccessful in the past in that, but we would be supportive of that section. It is Section 2 of this measure that we do have, we wanted to continue to work with the legislature on. We do have processes in place that already in the department that cover this, but we do want to point out that a lot of what happens here is that it goes beyond just the Department of Education. When someone is being harassing, and it is not for us, we are not law enforcement. What we do is we call law enforcement often to put forward a TRO or other means of doing that. And the department that doesn't fit in our wheelhouse. So that is something we would like to work with other agencies on, and we think belongs with those agencies. But if this bill does continue to move forward, and we are willing to have that conversation, we do ask that the bill does assign a full-time employee as well as responsibilities, but does not give us a position or the funding for that. So if this does move forward, we would request that as well. But available for any questions you might have. Thank you.
Thank you very much. Next, we have testimony in opposition from the Office of Public Defender. Welcome, sir. Please proceed.
Thank you. Good afternoon.
Chair, Vice Chair, and members of the committee. My name is William Bento. I'm a Deputy Public Defender. Although the Public Defender's Office believes in all of our schools being safe environments for everybody, we do oppose one part of this bill, and that is the creation of the section dealing with harassment of an educational worker. As stated in our written testimony, we uniformly will oppose any language that chooses to elevate one group of people above everybody else. In this situation, educational workers would be given, I guess in a sense, more protection. But we believe also that it's a false type of protection because there really is no impact to public safety or measurable deterrent effect when you elevate one group above another. The language of the bill dealing with when it would take effect, and I'll quote, because of the educational worker's position as an educational worker is very, very broad. And it could include someone yelling at a coach at a football or a baseball game, but it could also include something that happened years before that people are still arguing over and had a link to something that happened at a school, and that could be brought up and this law could take effect in that situation. I think we have to take into consideration what's going to happen if there are two educational workers, perhaps even at the same school or different schools, that get into some sort of dispute. Will it affect them? Yes. Lastly, I just want to point out that when you get charged with a misdemeanor, you're allowed to ask for a jury trial. So because of some sort of unreasonable taunt or something of that nature, a person can demand a jury trial. As an attorney, I will tell you this. I would recommend to my clients to ask for a jury trial in many of these situations. And that is a tremendous added cost. Instead of half a day in district court with one judge deciding the case, we're talking about 2, maybe 3 days for a jury trial, depending on the situation. Thank you, and I'll be available to answer any questions.
Thank you very much. We have testimony and support from the Hawaii Government Employees Association. Testimony and support from the Hawaii State AFL-CIO. Testimony and support from Lindsay Chambers. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. Thank you for considering HB 1651. I stand on my written testimony in support of the bill and would like to add the following. A group of current and former educational workers who are victims of ongoing harassment through the course of their employment with the DOE took it upon themselves to improve what the department introduced last session with HB 2125. If you look at the testimony provided under that bill to this committee last session, you will see a significant number of DOE leaders in strong support, many of them talking about harassment of educational workers being a severe and pervasive problem. I lived through the trauma of harassment and experienced the profound institutional betrayal from the very leaders entrusted to support and protect me. I enjoyed the work that I was able to do at the DOE and was passionate about it. However, I reached a point where leaving became essential for the safety of myself and my family and my overall health. Reflecting on the irony of how many times I wrote parent and staff letters reassuring them that the welfare of students and staff was paramount, I found it increasingly difficult to maintain trust in an institution that neglected this fundamental responsibility. How could I continue to defend a department that not only failed to shield me, but also directly contributed to the ordeal? Their guidance for me to obtain a TRO to protect members of my team who were being harassed, followed by their directive that the AG and DOE would not support me in this legal proceedings, put a target on my back as well as my family's, as my husband had to represent me in court. Despite no longer being at the DOE, I continue to advocate for the safety of educational workers because I wish that someone had done that work before me. My family and I endured a traumatic ordeal that could have been prevented. I'm committed to sparing future educational workers from such a life-altering experience. Thank you for your time and consideration.
Thank you, Ms. Chambers. Next, we have testimony and support from Inger Stonehill. Please proceed.
Yes, good afternoon, committee, the Judiciary Committee and Hawaiian Affairs. I'm Inger Stonehill, and I'm submitting this testimony in support. I do have written testimony, but I would like to highlight some certain areas, just like Ms. Chambers. Sorry, her testimony was emotional for me. Okay, I would like to say from last session in the Education Committee, the Attorney General recommended that we remove the requirement for the DOE to assist educational workers in obtaining representation from the Department of the Attorney General. I do understand the term representation may benefit from further clarification within the context of this bill. Drawing also from my own distressing experience, I didn't require an attorney to represent me. Rather, I needed assistance from someone well-versed in legal matters to navigate the complexities of obtaining a TRO. The process was daunting and traumatic, and I lacked guidance. Despite some considering it a personal matter, I believe involving the DOE and the Attorney General, who represent the DOE, would have provided the necessary support, addressing my concerns and ensuring my safety. As a special education teacher, I have attended conferences where the Attorney General was present due to concerns about possible due process. It strikes me that the AG could similarly be involved when an educational worker faces severe harassment, potentially reaching the point of physical threats. The importance of our safety should not be overshadowed by legal nuances, and I urge you to consider the significance of legislative intervention and action to rectify these flaws. Furthermore, like I said, I would like to reinstate that language, getting support from the Department of Attorney General and from the harassment. And lastly, while the term representation may be reconsidered, because that was what was some problems, for a more supportive connotation, it is crucial for everyone to acknowledge the necessity for educational workers not to feel isolated in their pursuit of safety. As indicated in other testimonies, enduring harassment from one community member, individual, parent for over a decade is unacceptable, and urgent action is warranted.
Thank you.
Yeah.
If you could
Thank
wrap
you.
it up, that'd be great. Any other
Yeah,
comments?
yeah.
Thank you
That's
very
it.
much. I appreciate that, Ms. Stonehill.
Thank you.
Next, we have testimony and support from Christian Chambers. Please proceed.
Thank you, Chair and Vice Chair. I appreciate the opportunity to testify before you. Unfortunately, I have some personal experience with this. You heard from my wife earlier. I am an attorney, and I was able to help her go through the legal process that was necessary to eventually get a restraining order against someone who was a known threat to the department for many years, had multiple TROs filed against him by other educators. And through that process, I saw a couple things that I think that you should be aware of. First of all, is that it is not reasonable to expect the average DOE employee to navigate that system on their own. It is a legal process. There are rules of evidence that become involved once you get to court. There are other things that matter. And having someone to help them do that is necessary. I can't count the number of handwritten TRO applications I was able to pull and see from DOE employees that just demonstrates that they need help, and not including anything in this bill that would provide that help is basically the same as telling them to go to WebMD if they suffer a workplace injury. It's just unreasonable, and it needs to be addressed. The AG's testimony before the Education Committee mentioned that they are generally not permitted to pursue affirmative claims on behalf of state employees. And I think that's probably correct. I don't pretend to know everything that goes on with the AG's office, but I do know there is an exception that the legislature has already carved out for that. And I've cited that in my written testimony, but that is with the involuntary hospitalization petitions. The legislature recognized that it's important to have legal assistance with that, and has the Attorney General's office helping anyone in the state who needs to do that, go through the process. It helps them, and it does that for them. I think something similar here is certainly required, especially when you're dealing with state employees who are being subject to criminal activity, criminal threats, and criminal harassment directed towards them because of their employment. The state does have an obligation to create a safe work environment And I think this is an important part of creating that.
Thank you.
And finally, I'll just note for the committee that there's no testimony and no one is coming before the committee denying the fact that this is a problem and that the employees need to be safe. You have the department testifying that they essentially are doing this already. And so moving forward with this bill is really going to do nothing more than make sure that what is supposed to happen does happen as we go forward and these folks are protected. And I'm happy to answer questions if you have any.
Thank you very much, Mr. Chambers. Next, we have written testimony and support from Tara Taitano, Jamie Song, and Shannon, and testimony in opposition from Brett Koldis. Is there anyone else here or online that wishes to testify in this measure? I'm told that there is. Angela, are you online? You want to testify? Please proceed.
Yes, I do. I'd like to testify. Thank you, Chair. Angela Melody Young, testifying on behalf of Kapalama Neighborhood Security Walk. We volunteer as safety coordinators because we care about the safety of students and the community. So we are in strong support to help schools, teachers, counselors, and students to recognize the signs of harassment and abuse at schools so that we can create a safe environment for all of Hawaii's keikis. Thank you.
Thank you very much. Appreciate your concise testimony. Is there anyone else wishing to testify on House Bill 1651? If not, questions, members. Representative Ganadin, please proceed.
To the Department of Education. Over the last few years, versions of this bill have come before the legislature. The legislature has declined to, I guess, prospectively add to the criminalization of parents who have grievances with public educators or with minors. I remember 2021 when a lot of parents were really unhappy with schools about everything. What kind of actions has the DOE done to protect educators as a result of what happened during COVID?
Yeah, so we've actually been, the cases that have been raised, unfortunately here, what we've been trying to do is we go after these individuals. We are trying to work with the AGs to prosecute some of these individuals, and what we're finding the difficulty is, for one reason or another, we are being told that we don't have enough evidence, or what we need to do, what we're finding is that we're being told you need to physically serve this individual or these individuals who are causing this harassing behavior so that they are aware that their behavior is harassment. And that has been a difficult proposition for us. We've not been able to serve some of these individuals, and that has been the reason why we're not able to prosecute this. And this is where we really are not experts in this area. We are wanting some help. You're hearing from some of the representatives, some of these testifiers, having help, having an attorney general being able to represent a state worker to go through that TRO process, I think would be one way to make sure we have airtight cases and that we can follow through with that. But we keep banging our heads against the wall. We came in 2021 to try and come forward with some type of legislation that we thought would help us. We weren't successful at that time. So we are just continuing to do what we can with what we are dealt with.
Well, this doesn't seem to be an issue with charter schools, private schools, certain other schools. I don't want to say it's an income thing or having to do with other issues, but it seems like those schools have a better relationship with parents and with teachers. Are there any lessons that we can learn from other educators and, say, forming better relationships about how to be civil with each other instead of bringing things to court cases or harassing each other?
That's a great question. I think part of it, though, if we look, it's not just, and I would also speak to the public defender's testimony. I don't think it's necessarily something that we want to carve out just for educators either. I think in general in the public, there's been a lot more vitriol, a little bit more aimed at state workers in general. I think you have seen it maybe even here at the legislature. Increasing penalties or protections for all state workers, I think is something we'd be totally supportive of. But in this case, we're looking at the narrow lens of our own schools. I'd be open to hearing any other lessons learned from the private schools or the charter schools. We are working with them on other issues, so we can definitely reach out and see what lessons they might be able to teach us on that.
Okay. Are there differing policies throughout the state regarding harassment per the school? So I'm sure that some schools, they don't have this issue at all, whereas other schools, it might come up pretty often. So do you have like a statewide policy, or is this kind of a school-by-school basis in which the principal or the central administrator kind of figures out what is best for that community?
So thank you for the question. So all of our administrators go through training that provide them guidance on what to do in these types of situations. It is the same training provided for all. So that guidance is the same. They are often in different school communities, and different communities have different situations that may be resulting in why some communities have more of these instances than others.
Okay, just one more, Chair.
Yes.
Should we pass this forward? Are you suggesting that police officers come on campus and collect evidence?
Well, we're just trying to figure out what the best way forward is. I don't know if that's necessarily the answer. We're trying to figure out what would be the best way to do that. I think one of the steps, and we're hearing from other testifiers, could be to provide the Attorney General's representation of someone going after a TRO. I think would be a great first step.
So you're not saying more police officers on campus?
I am not saying necessarily more police officers on campus.
Thank you.
Yep.
Any other questions, members? I have a question, if not. So you have a Safety, Security, and Emergency Preparedness branch,
Yes.
and they're supposed to be working to protect your schools and the workers at the schools.
So they have a very broad responsibility. Beyond that, they also are helping with natural disasters, all types of different anything related to school safety as well as emergency preparedness. But yes, they are involved. They get involved with, and in some of these cases, they were involved in helping to create a safety plan with these individuals.
This has been an ongoing issue for a long time, and I'm hearing from people who are testifying today that they feel like the department has failed them. And you're coming to the legislature, have us solve your problem. I think you need to solve the problem. And there's, every employer has to protect their employees. Here at the legislature, we have to do that. So we've got to, that's the responsibility of it. So I'm struggling with, you're wanting us to give you more money, tell the AG they have to do something, but you're an employer. You need to do this to protect. You're losing employees because you're not, to me, fulfilling your responsibilities as an employer. What are you doing to try to address this rather than coming to us?
So thank you, Chair. So I would like to say that this bill is not our bill. So we did not come forward towards you
No,
guys.
but you're asking for it, and you're saying, please give us another, give us more positions, and if we were to do this, tell the AG that they gotta. So, I mean, it's not your bill, yes, but.
Correct. So, and again, we are trying to address as this bill moves forward to make it so that it's not unworkable for us. So we are trying to find a way to make this bill workable. We are on our own still trying to work with the AGs to figure out how best to prosecute these types of individuals, as well as going after everything we can do to do that. But that is what we're trying to do here.
Rather than us giving you additional resources, is there any way you could move around your existing resources, which are substantial, to, in your administration, not take away from the teacher side, but in your administration side, to put more effort toward this?
So I know it does look like our resources are substantial. Our responsibilities are also substantial as well.
Certainly.
We do educate our children. We do a lot. We feed our children. We also provide health care for many of them when they're at schools where they aren't able to do that as well. So there's a lot the department does. We totally believe in keeping everyone safe as well as healthy and doing everything we can to educate them. But that is a responsibility we take very seriously, and we do our best to do what we can.
Yeah. Well, I appreciate that you're trying hard. It just seems like coming to us to solve the problem that really is a problem that the employer should be solving is where I'm having some challenges. So.
Understood.
Thank you. Any other questions, members? If not, let's move on. Thank you very much for your testimony. Next, House Bill 2043 relating to education. This bill establishes a harm to students registry for all preschools and K-12 educational institutions within the state that contains information on school employees, contractors, or volunteers for whom, as a result of an investigation, a final finding has been issued that the individual has inflicted harm on a student. And it defines what that means, inflicted harm on a student. It allows for an appeal process to remove an individual's name from the registry and appropriates funds. Okay, for this measure, we have testimony from the Department of the Attorney General. Welcome. Please introduce yourself and proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members, and Horiuchi, Department of the Attorney General. To summarize a few points that we made in our testimony, first thing we note is that the sex offender registry is one that requires criminal conviction in court, while the listing on the registry that's proposed by this measure would only require an educational institution to conduct an investigation and reach findings, and this is all done outside of a court of law. Also, we note that because this registry, as contemplated in the bill, would be maintained by the Department of Education, normally that would subject such government records to potential disclosure under the Uniform Information Practices Act. Because the registry will include highly sensitive employment information of non-governmental employees, we strongly recommend that the registry and the employment records of non-government employees be exempted from the Uniform Information Practices Act. And we've also included a suggested revision in our testimony to prevent the potential disclosure of information that would be protected under the Family Educational FERPA. And we've set forth a number of other suggested revisions in our testimony. I'm available for questions.
Thank you very much. Next, we have testimony and support from the State Department of Human Resources. Welcome.
Good afternoon, Chair, Vice Chair, and members of the committee. I'm Brenna Hashimoto, the Director of the Department of Human Resources Development. We're in support of this measure, and I'll stand on my written testimony. We appreciate being included as an employer that would have access to that information in conducting suitability investigations for state employees. Thank you.
Thank you very much. Next, we have testimony and support from the Executive Office on Early Learning.
Aloha Chair, Vice Chair, and members of the committee. Thank you for the opportunity to testify in support of this measure. We stand on our written testimony and appreciate the legislature's inclusion of EOEL into the measure. Happy to answer any questions. Mahalo.
Thank you. Next, we have testimony and support from the Department of Education.
Good afternoon, Chair, Vice Chair, members of the committee. Sean Bacon, Assistant Superintendent for the Department of Education. Department stands on its written testimony and support. Really, the intent of this measure is to create this registry for both private and public schools to be able to share information to those that have went through an investigation and found to cause any harm to students. We just want to make sure that we can share that information to ensure that people aren't moving from one institution to the other so we can protect our keiki. Available to answer any questions. Thank you.
Thank you. Next, we have testimony and support from Philip Bossert, Hawaii Association of Independent Schools. Welcome, sir. Please proceed.
Chair Tarnas, Vice Chair Takayama, thank you very much for letting me testify. I will stand on our testimony as written in very strong support of this. And as the Assistant Superintendent said, you know, we've been working for almost a year together to try to make this registry concept work so that we can share information on the bad actors that sneak out of one school and then drop into another. And I reviewed, while I was sitting there, the comments of the Attorney General, and I think that almost all of those are workable within in a revised version of this. And so happy to answer any questions.
Thank you. We have testimony, written testimony and support from Punahou School, Kamehameha Schools, and Department of Human Services. Anyone else wishing to testify on HB 2043? If not, I would like to have the Attorney General ask a question. Any questions from anyone else? Okay, please come on up. I'm very concerned about if this were to move forward, that this has got all kinds of challenges that you point out in your testimony. Extrajudicial investigation that determines that someone was causing harm, and including names and information. I mean, it just seems like this is a recipe for a major lawsuit. When they said, you know, the folks who are working on this, including our own, you know, who are folks from the Department of Human Resources, very glad to be involved with it, have you been advising them, or has anybody come to the Attorney General to ask for assistance on this? Because it seems like it needed some really good legal review, which it didn't seem to get.
I have not personally been involved in any meetings of this nature, I think, and so when I saw this bill, I don't know if this has been shared with others in the department, but what's in our testimony is the department's concerns we're raising. I mean, we point out, for example, there could be a situation of, say, an employee who's been accused of inflicting harm upon a student. There's the school, whatever school it might be, conducts an investigation, reaches their own factual findings. I think the standard in the bill is preponderance of evidence, and finds that there's been infliction of harm on a student, puts that employee's name on the registry, but in a court of law, if it's gone the criminal route, they could be exonerated.
Yeah.
So I'm not sure I understand what the concerns are raised by the educational institutions, but these are concerns that the Attorney General's Department has raised.
Understood. Okay, thank you. Could I ask the Department of Human Resources, since you're an expert in employment law, or at least if not law, then how to manage employees? It seems to me that this would expose everybody involved in it to significant risk because of the extrajudicial process of doing the investigation, making a determination, and and branding these people as causing harm to students. Do you share any of those concerns the Attorney General just brought up?
I do. So I might point out, though, that the Department of Education has their own human resources system and their own human resources operation independent of DHERD. So they would be doing the suitability investigation for DOE. DHERD handles suitabilities for other state jobs independent of DOE. So, but we do have, so first of all, when we do a suitability investigation, we're considering many things, some criminal, some not criminal. For example, we do criminal history record checks. We also look at driving abstracts, if it's relevant. We do reference checks. We do all sorts of gathering information to determine whether somebody who is a candidate for a state job is suitable. And yes. I use that in a very broad sense. There's, I know, for example, I came from DHS, and we did checks, or not me personally, but our staff did checks of the child welfare system. So those charges or those allegations didn't necessarily make it to the court system, but they're relevant if you're putting somebody in contact with a minor, and especially in those kinds of close relationships when you're dealing with vulnerable children. So we wouldn't use that information for all suitability investigations, but just ones where the job involves dealing closely with students or minors.
Okay, well, thank you very much. Could I have the Department of Education?
I might also add that we always give the applicant an opportunity to respond to whatever we're considering when we do a suitability investigation. They have an opportunity to rebut any information, provide additional details.
Okay, all right, thanks. Department of Education, have your attorneys looked at this proposed bill, and your human resources, your employment law specialists? Does this pass muster with your attorneys?
Thank you for the question, Chair. So when we were working on this, we were working in conjunction with the Attorney General's office, with our Educational Law Division AG there. They did give input on it. In the end, I do not believe that they signed off on it, but they were helping us with it through that process.
So they have not given their stamp of approval to this language?
I think, in general, they've worked and helped us through this process. I don't think it's went through I'd have to go back and check, but I don't believe it's went through the full entire process.
And why not?
I'd have to go back and in on that. I have not been involved in all of the discussions or conversations, Chair.
It just seems like you're asking us to do something that you're supposed to be doing, to come up with something that is legally defensible, because I'm concerned that you and the state would end up getting sued because of somebody who says you're doing something that is not defensible. And I just don't know whether your attorneys have said, yes, this is good, sign off on it.
Again, Chair, I'd have to go back and check on exactly where it was in the process.
Yeah, yeah. Okay.
Thank
All
you.
right. Thank you. Any other questions, members? If not, thanks very much. Let's go on to the last measure. House Bill 2722 relating to youth fees and fines. This measure prohibits the assessment of any fees, fines, or court costs against a person who was adjudicated for an offense committed during the person's minority or against the person's parent or guardian, and discharges all related debt obligations assessed prior to the effective date of the act. On this measure, we have testimony and support from the Office of the Public Defender.
Good afternoon again. Deputy Public Defender Darcia Forrester. I'm here in my capacity as the supervisor of our juvenile division. So we have submitted written testimony. We are in strong support, but if I may, I have some technical requests. On page 81, line 11, instead of the word reimbursement, I think that should actually say restitution. So I'd like to submit that. And then there's just one more of a, I think, a typo. On page 45, line 16, I think we can take out the word for. It says order for restitution. There are other, this sentence is repeated throughout the bill, but for some reason, the for was added in this section. So to make it consistent with all the other times, the exception regarding restitution is referred to, just to make it consistent. And just to be clear, this bill does not impact restitution at all. It impacts fines and fees, court-ordered fines and fees. And I'm available for questions if you have any follow-up.
Great, thank you. Next, we have testimony with comments in writing from Judge Viola, the judiciary, and testimony and support from ACLU. Please come on up.
Aloha Chair, Vice Chair, committee members, Carrie-Ann Chirota on behalf of the ACLU. We strongly support this measure. As many of you know, for the last 15 plus years, our criminal youth system, our juvenile youth system has transformed. And other jurisdictions have been looking towards us because we have worked collectively with stakeholders from judiciary to community to transform our system. This particular bill would move us further. It's in alignment and moves us in that direction. The national research is clear that fines and fees imposed on youth are ineffective and it does not support rehabilitation. In fact, the opposite. The higher the rate or more excessive fines and fees, it shows actually they can enhance recidivism. And this, as we know, most disparately impacts Native Hawaiian and Pacific youth and under-resourced members of our communities. So we ask that you continue the trajectory of our criminal youth system and following best practices, and please pass this measure. Thank you.
Thank you very much. Next, we have testimony and support from the Berkeley PAC Police Advocacy Clinic. Please proceed online.
Hi, good afternoon, Chair, Vice Chair, and committee members. I'm Ava Kargosha, a public policy graduate student in the Policy Advocacy Clinic at UC Berkeley School of Law. On behalf of the National Debt-Free Justice Campaign, we respectfully ask for your aye vote on House Bill 2722 to eliminate fees and fines in cases against minors under the age of 18. We stand on our written testimony and are happy to answer questions. We want to also emphasize that this bill is not to repeal restitution or to affect ongoing restitution obligations. With the disproportionate representation of Native Hawaiian and Pacific Islander youth in the justice system, fines and fees do the most harm to already marginalized communities. This bill ensures that state law conforms with state practice. The Hawaii State Judiciary has confirmed that family courts across the state rarely impose fines, fees, and costs on youth and their families. And in 2021, the prosecuting attorney in Kauai issued a memorandum voluntarily declining to seek fines and fees in cases against youth and their families. By passing House Bill 2722, Hawaii will join the national movement to achieve debt-free justice. We respectfully ask for your aye vote. Thank you.
Thank you very much. Next, we have testimony in writing and support from the Hawaii Friends of Restorative Justice. And then finally, we have testimony and support from Angela Young online, not present. Anyone else wishing to testify on House Bill 2722? If not, questions, members? Representative Ganadin.
To the Office of the Public Defender, Ms. Forrester.
Hello again.
Thank you so much for your continued work in assisting minors before the court. Can you explain to the committee what has happened in the last decade here in Hawaii? I mean, it just, okay, that's a big.
I know
So
what you mean.
So basically what I'm trying to prompt you to briefly explain is the great strides that the state has made in reducing childhood incarceration, in supporting trauma-informed care, in reducing incidences with law enforcement for not just Hawaiian and Pacific Islander youth, but all youth, and the sort of celebration that we've seen in the reduced criminality of youth throughout the state.
Okay, so it's big. So I'll try to
briefly
summarize it. Hawaii is a leader in juvenile justice. We have maybe over the past 10 to 15 years dramatically reduced the incarceration of our youth, reduced the population in our youth prison and youth detention home, increased diversion programs, increased services, increased access to things like substance abuse assessments and care, mental health services. And it has been completely transformed. And I think last year we had a period of time where we had no girls incarcerated. And we were one of the leaders in that movement. So the Berkeley Policy Advocacy Clinic has been working for approximately 3 years to eliminate fines and fees in the state of Hawaii as part of a national movement. And we've been tweaking this bill, tweaking it. This is, I think, the cleanest bill that we've got and the most comprehensive. And it's part of a national movement. And we're very proud of the progress we've made.
Would it be fair to say that much of this success is not the result of the legislature, but instead the result of community advocates, the judiciary, the members of the Department of Public Safety that understand the way to treat minors, and nonprofits?
I would agree 100%. The judiciary has been a leader in the movement, and by including stakeholders like Mr. Patterson, who is the administrator of the Hawaii Youth Correctional Facility at Kawailoa, and other stakeholders across the state, it has been a joint effort.
So it's almost as if this joint effort has been in spite of the legislature, not with the assistance of the legislature kind of thing?
I wouldn't say in spite of, that's a little strong. I would say with the help of the legislature.
Thank you so much.
Okay.
Thank you. Any other questions? If not, thank you very much to all the testifiers for being here today. We're going to go on to decision-making. Up to the top of the agenda, House Bill 2064. We only received testimony from just the Department of Education, and they deferred to Department of Law Enforcement since it's in their statute. Department of Law Enforcement did not testify, so I would recommend we defer this measure until a future hearing, and I've requested when Mr. Vincent was here for the Department of Law Enforcement to provide us some input on this, so at least we have that to make a decision on what we should do. So for the time being, let's just defer House Bill 2064. If we get the input and I think we're ready to make a decision, I'll put it on a future agenda. Moving on, House Bill 2071, I'd like to recommend move this out as is. It already has a defective date. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2071 HD1 passing as is. Chair and Vice Chair vote aye. Representative Evslin?
Aye.
Representative Ganadin?
Aye.
Representative Holt? Aye. Representative Ichiyama? Aye. Representative Ilagan? Excused. Representative Kong? Aye. Representative Miyake excused. Representative Souza?
Aye.
Chair, your recommendation is adopted.
Thank you. Next measure, House Bill 2621. I recommend we amend this measure, House Draft 1, make some technical amendments, defect the effective date to year 3000. I would like to take the public defender's recommendation that they be added to the task force. I would like to take the recommendation of the ACLU that a representative of an organization involved with the communities affected by this program are also on the task force. And I'd like to modify where there's a blank in terms of how many years back they should be looking at. We just say page 3, line 13, that they should look to the period from the onset of the program. That's my recommendation for an HD1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2621 with amendments, noting the excused absence of Representatives Ilagan and Miyake. Anyone voting?
Here's Mr. Ilagan.
Oops. Noting the excused absence of Representative Miyake only. Any members wishing to vote with reservations? Representative Holt? Reservations for Representative Holt. Any other members? Seeing none, Chair, your recommendation is adopted.
Thank you. On the next measure, House Bill 2218, relating to the Hawaiian Homes Commission. I recommend we move this out as is. It already has a defective effective date, and I think this is an important measure to assist the Hawaiian Homes. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2218 HD1 as is. Any reservations or noes? Your recommendation is adopted.
Thank you. Next measure, House Bill 1886. This measure I'd like to move out with the House Draft 1. I'd like to revise the preamble to make it more concise, defect the effective date to year 3000, make some technical amendments. And I will include in the Standing Committee report the concerns expressed by the Attorney General on a very similar bill last year that said that the Fire Council should conform its purposes in order to make sure they can actually implement the things that this bill is proposing. And so I would look to the Fire Council to provide that information to the next committee so that they could make changes as that committee sees fit. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1886 with amendments. Anyone with reservations or no? Seeing none, your recommendation is adopted.
Thank you. House Bill 2232, relating to weapons. I recommend we move out of House Draft 1 with some technical amendments, defect the effective date to year 3000, and incorporate the Attorney General's amendments in their testimony. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2232 with amendments. Anyone with reservations or noes? Your recommendation is adopted.
Thank you. Next measure, House Bill 2295, relating to the traffic code. I recommend we move out an amended version, House Draft 1, by defecting the effective date to the year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2295 with amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. On the next measure, House Bill 2455, relating to private security contracts, I recommend we move this out with the House Draft 1 by defecting the effective date to year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2455 with amendments. Any reservations, noes? Seeing none, your recommendation is adopted.
Thank you. On the next measure, House Bill 2266, I think that the lifeguards are already covered by the State Tort Liability Act, and that we shouldn't carve them out, or we shouldn't provide any sort of immunity to them. And I would urge the Department of Land and Natural Resources and your deputies, Attorney General, to really drill down into this issue, because it keeps coming back to us. But I think from what I can read in the law, they're covered. So if you could please follow up and work with the counties to figure out why is there this disconnect between what I think is clearly in the law and what the counties are saying. Because I agree with you, the DLNR really wants to work carefully with its partners in the county, and something is misunderstood here, it seems. So if you So what I propose to do is to defer House Bill 2266. Questions or concerns, members? If not, let's move on to the next one. House Bill 1537. On this measure, proposing amendments to the state constitution to authorize the legislature to establish a surcharge on residential investment property to increase funding for public education. I'd like to move this out with a House Draft 1 with some technical amendments. I think that in light of the decision in the 2018 Supreme Court case, City and County of Honolulu versus the State of Hawaii, which held that I think a similarly worded question had violated the statute, which requires that a proposed constitutional amendment be clear and concise, that I would like to recommend changing the language of the proposed ballot question to clarify the specific intent of the bill, to define the term investment real property, which was one of the reasons given in the 2018 court decision. I'd also like to note that since the 2018 decision, the legislature has mandated that the Office of Elections produce a digital voter guide that will include a detailed explanation of the ballot question beginning in the 2024 November election. And so the lack of complementary materials to the ballot question was part of the 2018 court decision to invalidate the previous attempt at this. Thus, the new voter guide would likely make a new, better written ballot question more defensible if it is challenged in court. I acknowledge the concerns from the realtors, and I think that needs to be made clear in the description in the voter guide so that people can make that decision. Are they willing to pay more as renters or property owners in order to do this? Just so people understand, this is the Judiciary Committee. Our job is to, in my view, is to do our best to make sure that what is included in here can stand up to judicial review. The Education Committee said this is a good idea. They want to move it forward. I'm trying to make sure this is a defensible language, and now it moves to Finance Committee, and they need to decide if it's in the best fiscal interest of the state to include this. So I would urge all of you who are advocates or opponents of this to move forward and focus your concerns about the fiscal impact on the Finance Committee, which is the next one. But with those, I'd like to amend the language in the bill and the ballot question so that it strengthens it, so that it reduces the risk that it could be challenged in court. Any questions or concerns, members? Yes, Representative Evslin.
Yeah, thank you, Chair. I'll be voting with reservations on this. I support increasing funding to the Department of Education. I have long supported increasing taxes on vacant investment homes. The problem that I see with this is that it would increase taxes on far more units than just vacant investment homes, and that the language clearly includes apartments, which I don't think it should. And there's also, I think, going to be confusion around the language. Kauai, for example, has a residential investor property tax rate, which excludes long-term rentals from the definition of that rate. This residential investment property would actually include long-term rentals if they're over $3 million. So I think a lot of people are not necessarily going to understand it, and it will apply to tens of thousands of actual long-term rentals in the state, which I don't believe we should be doing. But I support it going forward in that I think there is a need for continued dialogue on it. Thank you.
Certainly. Other questions or concerns, members? Representative Holt?
I just was wondering, could you repeat the question that's actually going to be on the ballot, or if we have that language?
I'm suggesting that we modify it. I have, it won't be exactly like this, but it's going to be modified slightly. We're going to change different parts of the bill as well, because I want to make sure it's clear that I'm going to modify it to make sure that it's clear to the public that the property taxes are actually levied by the counties, and that this would be a state surcharge on the real property taxation, which is levied by the counties, and that it would clearly exempt the surcharge from any home that serves as an owner's primary residence, and that it would be allowed to help fund public education for all of Hawaii's children. So that's in general what I'd be looking at, but I'm going to be looking to our House Majority Staff Office to actually craft the final language. But that's, I do want to make sure those specific things are included in here.
Thank you.
Yeah. Questions or concerns, members, other members? Representative Kong.
Oh, you know how much I support HSTA and company, but I will oppose this bill. Go no.
Okay.
I have a feeling it's just going to end up the same. And then HSTA is going to be banking on this and not expecting any increase in the funding, which we should do.
Okay.
Yeah, out of the general funds, right? So I don't want them to have high hopes.
I would agree. Measure the expectations. Yeah, don't count on this. Yeah. Thank you. Other questions or concerns? Vote your conscience. Thank you. Vice Chair for the vote.
Voting on House Bill 1537, House Draft 2, noting the reservations of Representative Evslin and the no vote of Representative Kong. Any other members voting with reservations? Reservations for Representative Holt? Or voting no? Seeing none, your recommendation's adopted.
Thank you. Next measure, House Bill 1651. I really am concerned that the Department of Education is not fulfilling its responsibility as an employer to take care of its employees, to address incidents of harassment. I don't think what this bill recommends is the right approach, and creating a total new offense of harassment of an educational worker. I think that the Department of Education needs to do a better job and not come to us to try to solve it. Even if this isn't your bill, I think it's not something that we can solve this way. So my recommendation is to defer this measure, and I'm open to questions or concerns from members. Yes, Representative Ganadin.
I'd just like to pay some thanks and respect to the people who testified, the folks that have had not wonderful incidences at work. The son of a public educator for 38 years, I feel like I've heard a lot about it. I think that the Department of Education needs to do just the chair said and create some rules around the safety of campuses and the proper behavior of students and parents as they interact with staff. Thank you so much.
Thank you. Other questions or concerns, members? If not, we'll move on. Next measure, House Bill 2043. I'm very concerned that if we move this bill forward and raise expectations, if this were to be instituted, it would place the DOE and frankly any other school that participates in this in jeopardy, because it would open them up to significant exposure for lawsuits by somebody who says that they did not receive due process. This is an extrajudicial review and finding that is not something that would meet the standards of any court. And so I recommend we defer this measure, and if people in the private schools and the public schools want to pursue this, you need to have the Attorney General from the public school to sign off on this, saying, yes, this is the best thing, because we have the Attorney General coming in saying it doesn't pass muster, and there's real concerns with it. And your deputy AG had helped you, but they didn't finally sign off on it either. So, sorry to disappoint you, but I just think that as a judiciary chair, the committee, I think that this isn't ready, and it's not for us to fix it for you. I think you got to go back and work on it. And I know you said you worked on it a long time, and I apologize, but it's just not ready. And you've really got to have your own AGs sign off on saying, yes, this is defensible. And I don't think it is. So I recommend we defer. I'm open to questions or concerns, members.
I just have comments.
Yes, Representative Souza.
Just comments. I think that I agree with what they're trying to do with creating a registry, but I do think that there's other ways of accomplishing the same goal, which is perhaps looking at ways of creating disclosure requirements by the schools or implementing some sort of process so that these educators basically won't won't get away with what they're doing when they go to the next school, and that the next school basically understands the liability that's involved. So I think that we can accomplish the same legislation, same laws, maybe just in a different way. Thank you.
Thank you. Other comments? If not, let's move on. House Bill 2722, I recommend we move out of House Draft 2 with some technical amendments, including the recommended amendments that we heard. On page 81, change the word reimbursement to restitution. Page 45, line 6, delete the word for. Those are my recommendations for House Draft 2. Questions or concerns, members? Yes? Yes, Representative Gannon.
Thank you, Chair, for passing this out. Thank you to the Office of the Public Defender, the judiciary, and so many stakeholders for their work in reducing trauma to children and in creating a safer community. I think no matter if we pass this out or we don't, the judiciary has made it clear that they have essentially ended the fees and fines for youth. So that's another success. It just adds to the trauma of continually bringing young people before the court. Thank you.
Yeah, I just want to make it clear, on page 81, we're changing, there. I think reimbursement is said twice in there, and we're going to remove one of them on page, to say restitution. Yeah, just want to make sure I'm clear on that one. Okay, any other comments? Yes, Representative Holt.
Thank you, Chair. I appreciate the intention of this measure. You know, just citing the Attorney General's testimony in the previous committee, it's their understanding that as it pertains to family courts across the state, fines, fees, and court costs are rarely imposed, and prohibiting such assessments merely takes away the discretion of the courts. I just feel that, you know, the courts in all their wisdom should have all the tools to implement fines and fees if they feel necessary. And I'll be voting no.
Understood, understood. Any other comments? If not, Vice Chair for the vote.
Voting on House Bill 2722, House Draft 2, noting the no vote of Representative Holt. Any other noes or Representative Ilagan? No. No vote for Representative Ilagan. Representative Kong? Reservations for Representative Kong. Chair, your recommendation is adopted.
Thank you. There being no further business before this committee, we are adjourned.